Good morning. Today I'm going to talk to you about the exemption from the South Carolina Residential Property Condition Disclosure Law. There are a few exemptions, but let me tell you, very few of them apply to your clients or customers. This is what we have to be very careful about. The first one here says, pursuant to court order, including transfers and administration of an estate, pursuant to writ of execution by foreclosure sale, trustee in a bankruptcy, etc., etc. What this means, if there's a court order to transfer property, it means that the court does not have to provide a property disclosure. But if a person gets the property via this method, when they get ready to sell it, they do have to have a property disclosure. Number 2 says, to a mortgagee from the mortgagor or his successor in interest in a mortgage, if the indebtedness is in default by a trustee pursuant to a deed of trust, or to a mortgagee pursuant to a mortgage, if the indebtedness is in default by a trustee under a mortgagee pursuant to a foreclosure sale, a mortgagee who has acquired the real property at a sale conducted pursuant to a judgment or order of foreclosure. The same thing, if a bank is in foreclosure, a property is in foreclosure, then the bank or the mortgagor does not have to provide a property disclosure. However, the person who buys it, when they get ready to sell it, they have to have one. Number 3, by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. Okay, the administration of an estate. The fiduciary or the administrator of the estate does not have to have one, but the person who inherited the property through the estate, when they sell, they have to have one. Then number 4, from one or more co-owners solely to one or more of the other co-owners. So if 3 people own a property together and one decides they want to get out of the partnership, they sell their interest to the others, then that person does not have to have a disclosure. However, if then those 2 who bought it from the one, when they sell, they have to have the property disclosure. Number 5, made solely to a spouse or person or persons in the lineal line of consanguinity, I can't even say that word, of one or more transferors. So, if a spouse is selling the house to the other spouse, then they don't need to have one. But that spouse who bought it, when they get ready to sell it, they have to have one. Number 6, between spouses resulting from a divorce decree, a support order, or marital property distribution order. So again, it's the same kind of thing. If the divorce says that the husband gets the property, then the wife does not have to have a disclosure giving it to the husband. But when the husband gets ready to sell it, he has to have one. Number 7, made by virtue of the record's owner's failure to pay federal, state, or local taxes. Okay, so the federal, state, or local tax people don't have to have a disclosure, but that person who got the property that way, when they sell it, they have to have a disclosure. Number 8, 2 are from the federal government. Same thing. The federal government does not have to have a disclosure, but the person who buys it from the federal government, when they get ready to sell it, they have to have a disclosure. Number 9, to the state, its agencies and departments and political subdivisions, including school districts. The same kind of thing. The state doesn't have, or the agencies, they don't have to have the disclosure, but the people who get it from there, when they get ready to sell it, they have to have one. Number 10, involving the first sale of a dwelling never inhabited. New construction, that is an exemption. New construction builders do not have to provide a property disclosure. Number 11, real property sold at public auctions. So the auctioneers, the people who are selling the property at auction, do not have to provide a property disclosure. However, if you purchase it from an auction, when you get ready to sell it, you have to have a property disclosure. Number 12, to a residential trust. The same kind of thing. The trust people who are selling the property from the trust to the public or to whomever, they don't have to provide it. But when you purchase it or get it via this method, when you sell it, you have to have a property disclosure. Number 13, between parties when both parties agree in writing not to complete a disclosure statement. This is about the only thing here that 98% of the time is going to apply to your buyers and sellers if both parties agree in writing not to have a property disclosure. Number 14, if a vacation time sharing plan is defined in section 2732.10, and if a vacation multiple ownership interest described. So if you have a timeshare and you're selling your portion of the timeshare, then that would be exempt. But the person who's been buying it would still need that property disclosure. So I hope this clarifies and clears up some of the misconceptions about the exemptions. We had one recently where the seller initialed all of these, not just one, but all of them, which of course is ludicrous. So if your seller is asking questions, you cannot do anything with the disclosure, but you can advise the seller of what is an exemption and what's not an exemption. As a matter of fact, that you should do that. Thank you.